name is Ali Saeed. I'm a attorney locally based out of Indianapolis, so just about an hour away from you guys. He was naming an organization that I'm also part of. It's Indiana Muslim Advocacy Network, and that's for a different time. I want to come here and talk to you guys about that organization as well at some point in time. But for today, it's mostly about me being an attorney and me doing some estate planning work. So I kind of want to get a sense of where the crowd that I'm talking to, just to get a better sense of how to tailor or spend more time or less time on certain issues. How many of you guys are have almost what we were expecting, right? I mean, we don't need to wait a few minutes. We're good.
No, you're good.
Okay. How many of you guys have an estate plan, like a will, or any kind of estate plan? Yeah, okay. Anybody with a trust? You actually have a trust, okay. So, today, what I wanted to predominantly talk about is a lot of people have already heard of will, right? It's pretty self-explanatory why you need a will. What most people don't know about is the differences between a trust and a will. Everybody sort of heard the terms. Most people don't understand. Most people that I run across, most people don't understand why would you need a trust, right? And so there's a whole lot of misconceptions. So things that I've heard all the time, right? I don't have tens of millions of dollars. Why do I need to create a trust, right? And I want to kind of dispel some of those notions, because having a trust has nothing to do with the amount of money that you have. There are a list of concerns that a trust helps you address. And my goal would be to tell you what those concerns are, right? Just give you a list of concerns, and then you guys can decide for yourself what you want. Now, I also want to I'm going to talk about some other items too, right? The trust is just one part of an estate plan. An estate plan is numerous documents, right? It starts with trust or a will. It has a healthcare directive. It has a living will. It has a power of attorney. So it's a full-on document that takes care of you both while you're alive and if you were to pass away for the benefit of your family. So here's what we. So most of why, I want to hear sort of also take a brief survey here just to understand what people were hoping to learn about as they came here, just so I can, again, get a better gauge.
What is the difference between will and a trust?
So we're going to talk at length about it. So but you want to learn about that.
Definitely.
That was something. Anything else that you guys saw on the intro and you were like, okay, this is something I'm inquisitive about?
We had a recent case.
Yeah, please.
Yeah, we had a recent case with one of the community where he passed away in elderly care, and he was cremated. He got cremated.
Oh wow!
Because he had no will, and the nurses who were taking care of him said that he told them that his body should be
cremated. Yeah,
we could not do anything.
Yeah. That's what you were saying.
I think the main thing is we just want to make sure, I think in the community, we wanted to make sure everybody was aware that it's important to have a will, especially if you have children. I think people sometimes just assume that the kids will go to the family members, but that may not happen. So it's important to have a will. I think the reason we wanted you to speak because we wanted to make sure Islamically what is a good way to approach this as opposed to just going to the lawyer down the street.
And so one thing I'll say up front, right? I'm not obviously a scholar on Islam, and so can't tell you guys about what are the exact ways money should be split according to Sharia, right? I mean, that's not my goal. But what I can tell you, we'll touch on Islamic law slightly and just tell you what's practical, what's not, in terms of if you wanted to implement Sharia law, which way you should, which routes you can take. And I'll tell you some examples of when people have come to me and we've structured something along those lines. So that's helpful. So I mean, one thing estate plans are all about, you have to make sure, I mean, it's what is going to happen to your assets. So obviously most people know that that's what it deals with, right? Assets, it's not for you, it's for your family. It's for the comfort of your family, right? You're not there anymore, obviously, if you've made an estate plan, but it avoids a lot of hassle for your family. And we'll talk a little bit about what those are. Some people have concerns about taxes, and we'll address and touch on that too. And I can tell you that very few people in this world or in the United States, where taxes on estate taxes after death are applicable to. Because there is a very high exemption. And so I'll touch on that. I'll tell you guys a little bit about that as well. Self-care, and what I mean by that is an estate plan should not only address what happens to you after you pass away, but it should also address what happens to you if you're incapacitated, right? I mean, the fact that ventilators have become such a common part of our conversations nowadays because of COVID, right? I mean, that's exactly what I mean, right? If you're on a ventilator, you can't take decisions on your own. What do you need in place to make sure your intentions and your wishes about your own body are implemented in the right way? So just things to look for. So we already went through this place. Now here's, I don't want you guys to focus too much on this. I'm going to give you some context of what happens when you pass away, and then I'll give some context to this schematically. So number one, let's start with this. What happens to you if you were to pass away, right? What would be the process that comes into play? So somebody in your family will have to go to the court system and open up an estate. Let's say you have no planning trust, right? Or even if you have a will, this will still be the case. You will need to go to the courthouse, somebody in your family, open up an estate.
I'm sharing
The slide.
yeah.
Oh, sure.
But you can
Okay,
keep it.
yeah. So, and the slide is not completely relevant right now to what I'm talking. I'm just giving some context. So even people on Zoom can sort of listen in and wait for the slide to come in. But so you pass away, your wife, or I always tell the husband first. So the husband is dead, the wife steps in, goes to the court, and opens up an estate, right? Now the court will then have to appoint somebody to take care of the estate, so be a fiduciary, right, of the estate. And that's generally going to be a spouse or a sister or immediate family member, right? And then you're going to have an attorney that's going to help that person side by side to help them execute when I say execute, what I mean is like distribute the assets. Now, one thing that's important to know about the court system is that the court system is set up to make sure the creditors are paid. Okay, it is not for the purpose of the beneficiaries, like the people left behind who are going to get the money. It's really set up for the benefit of the creditors. Okay, which means that the court system is deficient when it's dealing with beneficiaries, people like the kids or the wife or surviving people, right? So the system is sort of set up in a way where it's only for the benefit of creditors, which makes sense. Because the government, what they don't want is people dying and creditors not getting paid, because the whole system will go down to its knees if that was the case. So they've set up the system in such a way that creditors are going to get paid. So the first thing that happens, husband passes away, wife goes to the court, opens up an estate. The court will gather all the assets, let's say, and put them in a pot, right? And make a list of all the creditors and put them in a pot, right? And the first person that gets paid are the creditors. So then all the assets are then used to pay off the creditors, the administrative costs of the estate, and pay all of the attorney's fees and things like that, right? So that's what goes out first. The second step after that is now the court has to distribute the remaining assets to beneficiaries. Okay, so the question is, well, who gets the money, right? Let's say there are kids or there's a wife and so on. Who gets the money, right? There are two ways the court will determine. If you have a will, the court will look at the will as guidance for how the money should be distributed. If there is no will at all, the court will look at what's called an intestacy scheme, right? So the state of Indiana has an intestacy scheme which says, if you die with a spouse, this is who gets the money. If you die with a spouse and kids, this is who gets the money. If you have a spouse and kids from another spouse, this is who gets the money. So there's a whole scheme that the state has developed that would guide the court, okay? So the system would be, somebody goes in, opens up an estate to the court pays off the creditors, pays the admin fee, and then distributes the assets based upon either one, what the will says, or two, what the Indiana state law says, right? So this should dispel this notion, this misconception, that because you have a will, you don't go to court. So even if you have a will, your family is going to court. Okay, so somebody will have to go to court, open up an estate, and go through that entire process. The only way to avoid the court process upon your death is by having a trust. That's the only way to do it. Okay. Now, and I'll go into what really does it mean to have a trust. Some people think it's like, is it like a box, is it documents, is it like going to court, license, what is it, right? I mean, I'll get into that, but for all intents and purposes, to answer the question of what avoids the court system, it's a trust. Now, coming back to this picture that I have, right? This gives some context to what this means. What this shows is all the things that are going to get paid out of your assets first, right? You have attorney's fees, executor fees, appraiser fees, creditor fees, filing fees, bond premiums. All of that goes out of your estate if you pass away and if it goes to the court system. So going through the process of probate, it's inconvenient because you have to go to court and your family has to deal with the court, right? I mean, for many of us who are immigrants, our families would not want to be in a situation where they have to deal with the courts. So that's already an inconvenience on its own. But let's say we even get past that. The process is cumbersome, not just because you're going to court, but because of the time, because how tough and how long it takes, but also because of the cost of it. Because you have to pay all of these costs, right? So here's the, so some of the reasons, so if I'm comparing trust versus, and for you guys have to decide this for yourself, right? If these are concerns you care about. There are people that come to me, they say, hey, I don't care, whether my family has to go to court. That's okay. They're very well versed in dealing with courts. We have a family attorney that will take care of everything. It's no big deal, okay? The cost, I don't care about the cost, right? I'm leaving $3 million for my family. If they have to pay $20,000, $30,000, $40,000, who cares, right? So, and just to give some context to the cost of this and the time, trust versus a will, right? If you go to the court system, you're going to roughly pay about 4% of the cost of your estate in expenses. Okay, so if it's 100,000, it'd be 4,000. If it's $1 million, it's 40,000. Okay, in a trust, you're really looking at 1%. Okay, so it's about 4 times less. It costs more to set up a trust initially, but it's significantly cheaper on the back end for your family. However, it does cost more. It takes money out of your, whether you want to spend that money on going to Disneyland or whether you want to set up a trust is the question you have to answer, right? The second piece is the time issue, right? So it is significantly more convenient to administer a trust because you don't have to go to the court system at all. You go to your attorney's office, whoever set up your trust, you go to your attorney's office, and the attorney says, all right, well, this is what you decided. We're going to distribute the assets this way, right? And that's all that needs to happen, right? You don't have to go through the whole court process. So inconvenience, cost, time, right? Now, and also during the pandemic, obviously, the court system has taken significantly longer for them to process the probates. Now, here's what I have on the screen. It's Jackie Kennedy's will, right? Why do I have Jackie Kennedy's will? Because it was public. It was filed on the court system. And I can show you tens of other celebrities' wills because they had a will and not a trust, right? Which brings me to the other concern that a trust is meant to address, which is privacy. Right? If you were to pass away with a will or no plan at all, the court system would have all your documents, right? The court system is going to publicly file your will. The court system would know exactly who your beneficiaries are. The court system is going to know and publicly file who your creditors are. And that's just the nature of the system. Now, so that raises a few different concerns, right? The privacy. So the privacy leads us into 3 big issues. Number one, I don't want, some people may say, I don't want other people to know about what's happening behind the scenes in my family, right? I don't want them to know my assets. I don't want them to know who I left the money for. Let's say I'm just inheriting one of my sons. Like, I don't want all my private business out being laundered in public. So that's an obvious concern with privacy, right? But there are a couple big concerns that are not very obvious with privacy. So as an attorney, I see this all the time in marketing things, okay? Attorneys pick up lists of dockets and market to certain types of clients, right? So for instance, if somebody has lawsuits filed against them for debt collection, you will start getting mail from debt collection defense attorneys. If you got into an accident, you'll start getting attorneys calling you for PI work, right, personal injury work. There's a reason why, because public dockets are the prime way where businesses and attorneys and marketing companies and investment companies target people, right? So what happens when somebody finds out and it's publicly posted that your kids just got $1 million in life insurance policy? What is gonna happen? The first thing that's gonna happen is investment companies and marketing companies are gonna show up at your 18-year-old son's home and try to tell him how he should spend that $1 million. And so that's a big concern many people don't account for, and that's the reality. This is not something that's sort of, that I'm coming up with. This is the reality. This absolutely happens all day, every day. And I'm not saying those marketing companies are immoral for doing this. They are identifying people who have money, who need to figure out what to do with that money, and they're going after them. So that's also something that a concern that's addressed by keeping things more private here. The other concern, and this is more on the debt side, the creditor side, right? So here's what I've seen in administering trust. When somebody has a will and the creditors know exactly how much money was processed, who's getting the money, the creditors come to the window and they say, hey, listen, you owe me $30,000. This guy owes me $30,000. Give me $30,000. I see your estate. You have $30,000. Everybody gets paid. When there's a trust, they don't have those documents. So what happens is they come to me and I tell them, well, I'm not allowed to share the documents with you. I can't tell you how much money is in the trust. Listen, there's not a whole lot of money in the trust. If you really want to find out, you can hire an attorney for $15,000, $20,000, go open up an estate and find out, or you can believe me. And so what that really does is it forces them to settle these claims for like a third or 50%. And so there is this added benefit of how the administration, that could be taxes, that could be creditors from credit cards, that could be anything, right? It's just privacy, even if, and also it also protects people from people who want to challenge who you're giving the money to, because now it's all private, right? Everybody, if you have a long lost brother who's going to come out of the woodwork because you have a $3 million insurance policy, that brother has no idea what's been posted. That brother doesn't know who's getting the money and how much money they're getting for them to challenge. So they're not going to come in because it's all private. So here's what I tell people that walk into my office. I tell them, listen, all I can do is tell you concerns that can be addressed with a trust and not a will. It's not my job to push you one way or another. All I can do is tell you the concerns, and if those concerns appeal to you, the trust is your option. If they don't, and for many people, it does not, because they don't care about certain things for specific family issues, right? Family concerns, they're like, we have a personal family attorney, we don't care about this, we're leaving so much money, it doesn't make a difference. So whatever their specific reasons are, these concerns are not a big issue for them. So those concerns are, number one, inconvenience of going to court. Number two, the time that's going to be spent in court while the assets are tied up in the court system. The time commitment and the cost of the probate system and the privacy, right? So those are the four concerns we try to address, and that's why we do it. And that should also dispel the notion that the reason why you need a trust is because you have a multi-million-dollar inheritance, right? That is not the reason. These concerns don't account for that. It's about these four basic issues, and that's why you get a trust. Any questions from one? Yeah,
So
please.
what is the time we're talking about?
Time period with a trust?
No, if you have to go to the court.
Yeah, it's about 6 to 12 months, right? So about 6 to 12 months in an average year without any pandemic issues. It's a few months if you have a trust. If you have a trust, it's going to be, a couple of months, month or 2 months, you can generally, but it depends on the asset too, right? I mean, some of these assets, if you are going to court, they could be distributed much earlier. Some of them get stuck, like let's say, for instance, you have a business and now the business is going through the court system and there are partners involved and there's a fight between the partners. Now that's going to get stuck, right? Now you're talking about a year or 2 year long process. So there's that piece. So it's sort of, it depends, but typically 6 to 12 months.
Yeah. Other than the assets, home or cash or bank, is it advisable to put even a business into trust?
Yeah, absolutely. So business is your asset, right? So almost all my clients who come in, who try to do a trust, we have them name their business in the name of the trust. And here's why that is also important. I mean, some people don't, and a lot of business owners come to me to create trusts for privacy, for anonymity, right? They want to be anonymous in what they own for multiple reasons, right? I have people who created something that they're sort of embarrassed of, but it makes a lot of money and they don't want to be known, right? So they want to put it in the name of the trust. So when somebody looks up the Secretary of State's website, their name doesn't pop up. It's the name of the trust that pops up, right? And the name of the trust is sort of like this obscure name that doesn't relate it back to that person. But the other reason is that if you have, let's say, especially the physicians, right? Physicians and people like engineers and professionals like you guys, right? Like what's going to happen is if, let's say one day I'm driving down and I run into a car, right? And accidentally, this person is gravely injured or dies. The person who I ran into. The concern, or if you're a physician and you have a malpractice case, right? You've accidentally killed somebody, right? Or I'm an attorney and I've lost somebody their entire business. Now there's a massive lawsuit coming on, right? I have an insurance policy, and that insurance policy is supposed to protect me in two substances. So the attorney who sued me is going to look at it and say, okay, do I want to come individually after this person, or do I just want to take the insurance policy and kind of walk away? Right? They're always going to have to be, they're going to be at this crossroads of making a decision whether they want to continue pursuing the lawsuit against you individually after the insurance company pays off. That decision is almost always based upon what your assets are, right? So at my office, we have a system, Lexus system, where I can do a people search and I can find out everything you own, who your family members are in Indiana and outside of Indiana, where you've lived in the last 10 years, just about every piece of information that I have, right? It looks through all of these public searches, who's owned what property, what real estate is under your name and all of that, right? The more things you keep out of your name helps you in that search when something like that happens. So business owners who don't want to be sued individually, they place the business in the name of the trust. So now when somebody looks up, Ali Saeed, his name doesn't pop up on the Secretary of State's website. It's the trust, and the trust is not connected to me. Nobody knows who the trust is owned by because it's private. So there's that added benefit for business owners. And I've seen a lot of physicians actually, frankly, do the trust because attorneys and physicians and some of the professionals, our liability goes beyond our insurance. And so even if my personal practice goes out of business, my liability will go into my personal life. So my house is on the hook and everything. So the more things I can kind of tuck away, which don't show up in my name, the less the chance that an attorney who's making a decision whether he wants to spend resources coming after me will do that. So any questions before I move on from this trust versus will issue? All right.
So what would be the typical assets? Like, can you put stocks also on this one?
Sorry, can we put what?
If you have stocks, if a person has.
Yeah, everything. Yeah. So investment accounts, you would just name the investment account, the beneficiary of the investment account as a trust. You may not name the trust, the stocks in the name of the trust, but you would just name the investment account's beneficiary as the trust. So a bank, you can do a transfer upon debt to the trust. The homes, you could do it similarly. Certain assets, the business, I would actually transfer the interest in the business to the trust. So let's say you have an LLC, I would say 100% of the LLC is owned by the trust, as opposed to you personally. And now this is called, and so let me explain this one piece too. That's a good question because it's a good segue. A trust is just an agreement. It's not something any different than it's an agreement between the person who created the trust, the grantor, the person who's administering the trust, the trustee, and the people who will receive the money from the trust, the beneficiary, right? A three-way agreement. The grantor who created the trust, the trustee, and the beneficiary. That's all it is. So you don't have to file it with the government. You don't have to do anything else. It's just a piece of, it's a few pieces of documents, right? 150 to be exact. Like, that's how big my trust is. So 150 pages, right? And it doesn't require any filing or anything like that. Now, if you are not giving up any control by creating a trust or naming things in the name of the trust. It is a revocable trust. It's called a living revocable trust, right? It's different than the irrevocable trust. There are different types of trusts. The one we're talking about today is a revocable trust that's a living trust. You owning property in the name of the trust is as good as you owning the property outright yourself. You're not giving up any control over this property at all. Because you're not giving up any control over this property, it also means you don't get any asset protection, which means you don't get to go to a judge and say, this asset is not mine. Okay? Though that people who have irrevocable trusts do that. That's a different conversation altogether. I don't want to complicate things. But in this scenario, you're not getting any protection from by saying to a creditor, hey, this is not my asset, this is a trust asset, because you have full control over it. And if you decide this is a bad idea for you someday and you want to scrap the whole trust, you can do it anytime. Because it's revocable, right? It's not irrevocable. So. All right, so. Should bring this down if I can. Yeah. So now I want to move on from this trust versus will thing. Yeah, go ahead.
There is a question on the Zoom. Someone saying mainly talk about pricing. I have asked around and some requests are from 4K to 6K. Is this pricing normal?
Yeah, that is normal, but here's what I want to do. I will answer that question, but let me give some context to that question, because once I'm done with all the slides, there will be more context to the question of pricing, just so that they understand what different types of documents are going through this. So I will address that. I'm not trying to dodge that question, but 4 to 6K is fairly normal. So here's one thing outside of the trust and the will issue. The next question comes in: why you need an estate plan is, do you want to give your kids the money outright? Right? Here's the question that comes up: if I was to pass away, do I want my kids to have the money at the age of 18? And the obvious answer for me was, I don't, right? Because I have had people who walked into my office who said that their kids got $50,000, right? Not a big sum of money, but $50,000, and they decided not to go to college because they got it at the age of 18. Because $50,000 to me today versus $50,000 when I was 18 is a big difference, right? And so I've had 2 clients that immediately come to mind when I talk about it. One got money at the age of 18, $50,000, and one got 150 at 21. They both did not go to college until they were in their 30s. And so, and that's the obvious consequence, right? So the way you want to do this, typically, this I can tell you what I have done. I can't tell you, everybody's kids are different, but I would want to give money to my kids in a way that it doesn't change the way that you make their decisions. They're sort of formative year decisions, right? Education, whether they want to start a business. I don't want that money to make that change that decision, because they wouldn't have had that money if I had not passed away, right? So why should it be any different if this money is there now? So I want them to make those decisions in a sort of thoughtful way. Now, even if, let's say for instance, so and you can address this both through a trust or a will, right? It doesn't have to be a trust and or a will. You can address this question of not giving it to them at 18. So what many people do is they give them the money, some money at 18, some money at 25, some money at 30, so you can stagger how you want to give them. Now, even if you do that, the next question is, for especially younger families or people with younger kids, if you lose your parents at a young age, it is more likely than not, well, that's an unfair statement. It is more likely, let me leave it at that, it is more likely that your kids make some bad decisions along the way. Okay? So if I was to lose my parents when I was 18 years old, I would make some bad decisions. I may get into creditor problems. I may marry somebody at an early age, right? Which means that there might be divorces, there might be creditor concerns. Okay? So how do we leave the money? So the question I've gotten, and there is a solution to this, is how do I give the money to my kids so it's protected from creditors? How do I give the money to my kids so it's protected from divorces, right? Because here's what would happen. If you were to give your money to your kid, your kid gets married to somebody, they get divorced, 50% of their money now ends with somebody else. And so your life savings are going to somebody that you never intended to, even though they were meant for the benefit of your children. So there are ways to structure your trusts or wills in a way where the money is given to the kids in a separate trust, and this one is an irrevocable trust, which they do give up some control, but then it's protected from creditors and it's protected from divorces, right? So I'll give you guys an example, I can answer some questions, this is a bit more complex, this piece, but it is sort of cutting edge estate planning. My kids will get, this is funny because my daughter heard somebody talk about this on a webinar and then asked me why she's getting her money at 30. So, but the way it's set up is that my kids will have, so the money will go into a trust after I pass away. And my wife passes away, let's say something catastrophic happens in a car accident or whatever, right? And the money now is going to funnel into this trust for them. They will have, my sister is the fiduciary, so she can give them as much money if they ask her, right? So if she feels like, I feel like she can make decisions the way I make decisions, and so she will stand in my shoes, right, and make those decisions. At the age of 25, my kids will become co-trustees, okay? So now they will learn how to invest that money and where their money is, right? Because many of us, the reality is many of us are richer in our debt than they are in their present life. Because we have life insurance policies, we have different things that will come in that our kids would get all of a sudden. So it's a fairly decent amount of money that may come in. So they need to learn how to invest that money. So between the age of 25 to 30, my kids will learn how to invest the money in co-trustee, their trust. At the age of, and during this time, my sister can give them as much money as she wants, but it's to her discretion. Now, up till that point, when they're 30, they will have full protection from creditors and full protection from divorces. Nobody can touch that money, right? And the reason is because they have no control over that money. See, the control versus protection is sort of a balancing game, right? The more control you have, the less protection you have. The more control you give up, the more protection you have, right? Because you can imagine, it's intuitive, right? You go to court and you say, hey, that's not my asset. The court says, why isn't that your asset? And you say, well, I can only ask for money, but my aunt may not give me any money. So the court can't access it, right? But if it's up to me to take out the money, then the court will say, go take out the money, right? So you get asset protection. So until 30, my kids, when they're more likely to make bad decisions, will have full asset protection. After the age of 30, they will be able to take out the money, they will become sole trustees, and they will be able to take out the money anytime they want for health, education, maintenance, and support, which is a very broad topic, broad categories. Nobody's looking over their shoulder. Essentially, they can take out the money for whatever reason they want. Now, after the age of 30, they do not have probably very limited to no creditor protection because they're sole trustees. However, they will have full divorce protection. So even if they get divorced, that money is theirs and nobody can touch it. So there are ways to structure things in a way where the money is given to your kids in a way which is protected from creditors and divorces, especially because we live in an environment where prenups are not the common theme. You can't force your kids to get into prenup. It is socially unacceptable to do that. So it's this is sort of some work that can be done ahead of time so that they don't even have to deal with that. So, any questions before I move on? All right. How many people have young kids here? Like, I'm talking about under 18, minor kids. Minors, okay. So, if you have a will, number one, it goes without saying, you need to have guardianship appointed for your kids, right? You need to have a will. There is a family that was based out of Indiana, and this is a story that a lot of estate planning attorneys share. This family went to Arizona with both their kids. The parents passed away in a car accident. The wife's sister, flew into Arizona, picked up the kids, okay? The husband's sister wanted guardianship of the kids. They started fighting, and they started slinging mud at each other. At the end of the day, what happened was about $300,000 in attorney's fees between the two of them. The judge took the kids from the wife's sister, gave it to the husband's sister, because they had defamed each other and told the judge, hey, listen, they're not responsible enough to take care of these kids. And because the judge didn't even trust the husband's sister, he appointed a financial guardian for the kids at $100 an hour. And the kids were extremely young at that time. So for about 7 or 8 years, the state was drained because they were paying a financial guardian, right? So there are the risk of not having guardians appointed exceeds beyond just your kids going to somebody who you don't want them to be with, right? It's not just about the kids not being with who you don't want. That's the most important thing. But even if that is not the case, what ends up happening is you are at a high risk of draining your estate with no money left for your kids if you don't appoint someone. Now, there's another very practical thing that's a gap in a lot of estate plans, and that is this. Even if you have a will, you've named guardians, right? Many of us are naming guardians who are not in the same state as us, right? So we are naming a kid, like our brothers and sisters who may live in Minnesota and some other state. And even if we've named somebody locally, what we're not doing is we're not handing them a copy of our will where they have paperwork to show the authorities that they have guardianship. And here's a practical concern that arises from that. And I ask my clients this all the time. They're walking into my room, we're sitting there through our sessions, and before they walk, I say, what happens if both of you guys on your way back home get into a car accident? Your kids are gonna be home, right? The cops are gonna go knocking on the door. You've named somebody that lives in California. By the time that person flies over to California, by the time that person finds the guardianship paperwork, by the time that person is able to get to the authorities, what do you think is happening to the kids? They're in foster care. So you've lost it. They just lost their parents. You have a will in place, but your kids are in foster care. And so there's very pragmatic ways to get to take care of those concerns, right? You make sure you appoint a short-term guardian. So wherever you guys go to in the future, if you guys have younger kids, make sure you're appointing a short-term guardian. Make sure you're letting the person who you appointed as a short-term guardian know that they're a short-term guardian. Make sure they have a copy of the documents with them. And make sure they have a copy, they have the card for your attorney that if they lose the documents, they can call their attorney. And so you have to make sure you fill in those gaps for the sake of your children. Any questions before I go move on from this topic of guardianship? Yeah.
We have two questions from the.
Yeah, absolutely.
So one is, what is the minimum amount of wealth to which you can use the asset? And the other is, what happens to a joint asset shared by parents and children if the parents?
Okay. So the first question, one, you don't have to register a trust, right? So I want to say you have to create a trust with an attorney. You don't have to register it anyway. There is no minimum amount, right? I have had brothers who wanted to set up a trust and they had less than $25,000 in wealth. And the reason why they were doing it were different, right? So there is no minimum requirement for setting up a trust. The second is, what happens to an asset if it depends on the asset, number one. But let's say, I'll give you an example of an asset. Let's say you have a house, right? Or, yeah, let's say you have a house, right? A house. And you and your husband, you and the wife, husband and wife own it together. And upon their death, the kids own it, right? So then you file what's called a transfer upon death deed. That upon the death of both the husband and wife, so after the husband, the wife would own it. After the wife, it would go to the kids. But most people don't do it that way. Most of the time, what you end up seeing is the husband and wife own it together. After the husband, it goes to the wife without the court being involved. However, after the wife, it goes to the court, right? Now, even if you have the kids named as transfer upon death beneficiaries, the problem with that is you can't control when they get the money or when they get the house, right? They'll get it at 18. And if they're under 18 when they get it, you're going back to court because the court is not gonna let them have the property in their name because they're minors. There's gonna be a guardian that's gonna be set up, and that guardian is gonna be monitoring the property as a financial guardian. So example is kind of a broad question, it's kind of tough to answer that went on, so I try to give an example. All right, are we talking about death enough, guys? Will you? Yeah, you signed up for it, so here we are. Healthcare directives. So there are two documents for your healthcare in any estate plan, right? Three documents, I would say. Number one is you need to have you need to appoint somebody as your healthcare representative. So it's a healthcare power of attorney essentially. And that person makes all your healthcare decisions. Then you have what's called a living will. The living will tells people what you want to happen to you if you were on a ventilator, right? So for instance, if the doctors have said you're going to pass away, you're on a ventilator, and you want to receive artificial nutrition and hydration, right? Those types of questions. And you need to tell people what your intent is, because if you don't tell people what your intent is, you're going to leave your family in a very bad situation. And that is probably the single biggest reason why families conflict with each other. The picture I have up is Terry Shiloh. It's a well-publicized case. This lady lived in Texas. She had a young family, went on life support. She stayed on life support for 8 years. When husband tried to take her off the life support, the mother did not want her to be taken off life support after 8 years. The doctors had said she was going to pass away. The battle went on, the court battle went on for about 4 years. This lady passed away while they were still battling it out in court. Okay. And all it did was just a lot of heartache for the family members. So it is critical that you have put the intention out there, because you don't know what's going to happen when grieving family members are going to not agree on something as critical as pulling the plug on somebody. So. All right, now this goes towards one of the questions that you had mentioned previously. Go ahead. Okay. And that was, well, can we avoid having a will or a trust or anything if we just name the properties together, right? So simple, I mean, this is a question I get quite a bit. Hey, I don't need a will, I don't need anything because I only own a home, and the home is owned by me and my wife, right? Or me and my husband. Well, sure, okay, so let's play this out. What happens? So when the husband dies, the wife gets the house. Okay, that's fair. You don't have to go to court. Nothing has to happen immediately after. If you own it as husband and wife, number one. If it's deeded properly, after the husband goes to the wife. But then after the wife, who does it go to? Now you have to go to court. So you may account for that by naming things together for the first death, but what about the second death, right? Same thing I've heard about, hey, I have a home and I have an IRA account, right? Retirement account. My home is titled to a husband and wife together, so after me, it's my wife's. And then I call them this piece, what I just told you guys. And then I have a retirement account. The retirement account is named in the name of the beneficiary who are my kids. Well, few problems. Number one, remember, we don't want our kids to have the money when they're 18. More than likely, we want to delay that process. There's no way to do that. You guys have all probably filled out your IRA beneficiary designation forms. There's no form on that, there's no provision in there that says give it to them at 30. It just says name of the beneficiary. Number two, if you pass away before your kids are 18, guess what happens? You end up in court, because the kids are not going to get the money when they're minors. The court is going to appoint a guardian. So it's not a foolproof plan. It's better than nothing, but it's not necessarily an estate plan, right? It's just naming things. And again, I just have the will on there because people think they don't have to go to court because they have a will, but it's worth noting again that that's not the case. All right, so we talked about this piece, about the trust. And we've discussed this as well. All right, so the tax piece. I know we had talked about estate taxes in Indiana. There's a federal estate tax exemption that applies to everybody in the US, and Indiana doesn't have its own. So that it's $12.06 million. So if you have $12 million, you don't have to pay any taxes. Any assets that you have beyond $12 million, it could be at 40%. So it's a high tax rate if you are inching towards. Now, the Biden administration is going to probably drop that down to about $7 million. So whatever assets you own after you pass away, if they're over about $7 million, you're going to pay 40% in taxes on that. But again, like that doesn't apply to a vast majority of the people. In fact, it's more than $7 million, but I don't want to get into nuance. But if that is a concern, you should certainly talk to an attorney. All right. So final thing, as we're inching towards, how much time do we have? How am I doing that? We're good. Okay. So here's just a typical experience. I want to. So I came from sort of a advocacy background. Some of you guys I was having lunch with, I was telling you guys that, you know, I did spend a lot of time doing consumer rights and civil rights work. And so when I started doing estate planning, I wanted to do it the right way. I kind of wanted to figure out what was missing from the system, what was the problem with the current estate planning attorney. And so I kind of went out and spoke with, so I had a friend who I used to refer cases to, about 30 cases a year or something like that. And I remember I would get some complaints from the people I referred. So I sat with some estate planning attorneys, I sat with my friends, I sat with some financial advisors, and I asked them just to get a gauge of what was happening. And this is something for you guys to know as you guys are meeting estate planning attorneys or drafting notes. So number one thing that I noticed was education, lack of education. People weren't being told why they were doing what they were doing. Somebody would call, like even today, I get calls, people say, hey, I want a will, I want a quote. I want a trust, I want a quote, right? Nobody's walking them through why they should get a trust, why they should get a will, why they should have a power of attorney. They have a power of attorney, but they don't know when it's going to be utilized. There's no real education. Nobody's telling them what should happen if you're a young family, if you have a blended family, what are concerns that you should look, right? There's no real education that's happening. My own partner's mom, she has a trust and it sits on her mantle. And when I ask her what's in it, she barely knows because she has no ongoing relationship with her attorney. She made this trust 10 years ago, never heard from the guy. She hasn't even titled things in the name of the trust, which means the trust is worth nothing. Because the only way the trust is worth something is if you title things in the name of the trust, right? That's the critical piece. So education was a big piece. The second big concern I saw was there was no asset inventory. Like there was no updated asset inventory. I don't know if you guys recall, there was a family that lived in Indiana. I think that's why you would probably know this family. The husband, the father and the son took a plane ride. They were going to go around the world and they were going to raise funds for the schools in developing countries. And they ended up, the plane ended up crashing. And so the father and the son passed away. Now, I remember like how painful it is when families lose someone they love and there's no list of assets that's left behind. And now the grieving spouses, the grieving kids have to sit on Pigeon Island, look through mail for weeks at a time while they're grieving, trying to figure out what is it that dad left behind, what is it that mom left behind. That's the worst, most painful thing you can put your family through, right? So it is absolutely critical that you make a list of your assets and identify. So if you have a bank account, who is the bank account with? What's the name of the account holder, right? If you have an IRA account, who is it with? Account policy number. Life insurance policy, who's it with? Policy number. That is so critical to have. And I was perplexed by seeing that people were walking away with estate plans without having an asset inventory. And when they don't talk to their attorney for 10 years, guess what happens? Nobody's badgering them about updating their asset inventory. Because how many of you will have the same asset 10 years from now? So that was the second biggest, gap that I saw in estate plans was, number one was education, number two was asset inventory. The third one was sort of personal to me because I told some of you guys this at lunch, when my father passed away about 6 years ago. My daughter was about 3 years old at that time. And when she was 4, so it was a year after my dad had passed away, I walk into the room and my daughter is crying. And she's about to go to sleep. She was supposed to be asleep. And I was like, "Marie, what are you doing? You need to be asleep." And she tells me, "Hey, I'm crying." I said, "Why are you crying?" So I find her crying. I'm like, "Why are you crying?" And she says, "It's because I don't remember Dada's name of face, and I don't remember what he sounded like." And it was the most innocent, but the most saddest way to tell me something that we are all so concerned about, right? We don't want to be forgotten, and we don't want to forget our loved ones. And we talk so much about wealth planning, and I heard nobody talk about legacy planning, right? All these estate planning attorneys, all the wealth management advisors, everybody was coming in and they were telling you your assets should be done this way, this way. Nobody was talking about values. Nobody was talking about legacy. So here's what I did, right? So, I tried to incorporate it, and this is sort of a model. If you guys go and find other estate planning attorneys, right? Try to ask for these things just so that, in my opinion, I did some soul searching and I came up with this. So I think it's valuable. So I make sure that I inform my clients, right? So when people come in, we sit down, we talk to them, we give them a wealth planning session, which is about 2 hours. It's free of cost. You come in, I make you fill out a pre-meeting packet, which is, and makes you list out every asset you have. And it gives me how many kids you have, what your family dynamic is. You walk into my office, and then for 2 hours, for an hour or so, we sit down and discuss, go asset by asset, telling you what would happen to your assets if you were to pass away. Who would they go to based on your family dynamic, based upon your planning? And then after that, we list out concerns, right? A list of concerns. These are the concerns we care about. Do you care about privacy? Do you care about this? Do you care about going to court? Does your family? And if based upon that, you tailor a plan. Now, after that, you want to make sure you have an attorney that has ongoing, consistent touches with you, right? Like they're keeping in touch. So every 3 years, we meet with our clients. You want to be with an attorney that's meeting with you regularly, at least every 3 years or so. So they are updating your plan, forcing, not per se making material changes to the plan, but at least forcing you to update your asset inventory, making sure they're keeping up with the law, telling you, hey, what we did last 3 years ago no longer jives with the law. We need to change this, right? Somebody who's keeping an eye, so it's not a failed plan. And so the last thing, and so that took care of the information piece and the asset inventory piece. Now, so we come up with an asset inventory, make sure it's updated. The last thing that we did is that when we give the binders, we record an interview with our clients, which is, and you guys can do this with your wealth advisors or whoever it is, right? And who has a record of all this. So we have some questions we ask. I mean, they're not super emo questions. They're just questions like, hey, where'd you grow up? How many siblings? How was life like? Tell me about your kids. What are the most, proudest moments you have with your kids, so on and so forth. And it's a present for the kid, right? It's something, and we make a video of that and we plug it into the estate plan. And if something happens, hey, the kids have that. And I've had my clients play it at funerals and various different places. And it's sort of a nice gift for the kids. So just something, if you guys are looking, I mean, I've done a lot of research on the market to figure out the gaps and all of that. So whether it's me, whether it's anybody else, right? If I was going out and making a plan, doing things, I would make sure you spend a lot of time with an attorney, making sure you get information. I would make sure that if you go to an attorney who doesn't talk about an asset inventory or has a process in place for you to keep up an asset inventory, I would walk away from that guy. And 3, I would urge you guys to find a way to do some legacy planning and not just limit yourself to wealth planning, because honestly, legacy planning might be more important than wealth planning for many of us. So that's sort of a wrap for me. I have, if you guys have those sheets, the reason why I gave you the sheets were if you were taking notes and you wanted to mark certain things up just to keep track of it. If you guys, I have some cards here. If you guys want to talk more, if you guys want to schedule 15-minute calls, whatever you guys want, right? I'm happy to do it. If you guys have an attorney, you want me to and you guys have a plan, you want to figure out, hey, Ali, do I even want to, look at something else? I'm happy to chat with you and just tell you, hey, listen, I think I think they did a good job. That's fine. Oh, let me see. Maybe we need to do this, and I can ask you some questions. So however you guys want this to go, we can do it. I do have my cards, and I'll handle that. Yeah.
So are these trusts federally regulated or?
It's state regulated. Oh, question that the brother had about the pricing. So, it's a 4,000 to 6,000 range is fairly. That's a fair estimate of trust, creating a trust. Like if you come to me, I will tell you, and you call me. Let's say we're on a 15-minute call, and you're saying, hey, I want a quote. I would say, hey, anywhere from $2,000 to $7,000, right? $2,000, you get a will, you get a power of attorney, you get all the documents, right? Like you get healthcare directives, everything, and the family wealth session, and I'll meet with you every 3 years, so on and so forth. If you the trust, if you get a trust with all the widgets in it, right? So there are various different types of trust. There's a trust that's they're revocable, irrevocable, all of that. If you get everything, the top end is 7,000. So that's sort of a range, and it's kind of tough to say what the price is because I don't know what somebody will get. So, but if your attorney charges you somewhere around that, that's probably I'm probably on the not the highest end, but between the medium to high.
So can someone have a trust and a will?
So we almost always do a trust and a will, and I'll tell you why. There's I think the reason why you're asking that question is different than why we do a trust and a will together. So there's no reason for a will and a trust together in a perfect scenario, because they do the same thing. They tell the system where the money would go. It's just a different way of doing it, right? A will force you to go to court and distribute the assets. A trust just forces you to go to your attorney and distribute the assets, right? The reason why we have a trust and a will always together is because it is very reasonable to expect that over the course of 10, 20, 30 years, people are going to forget to name things in the name of the trust, right? So now you're going to have, but because the trust is an agreement that only controls assets which are named or titled in the name of the trust, right? So now if you, let's say you open up a bank account, you forgot to do it, now the trust doesn't control it. So the reason why we have the will is sort of a pour over will, right? So it routes it picks up the broken pieces and sort of routes them back into the trust. So that's the only purpose of the will in our set.
So I have a question.
Yeah, please.
So if, I have parents and they have will for me and I may not have used my child, what I do have, but I died and I have my parents still alive. What happens to their will going to my kids?
So if your parents have a will, right, and something happens to you, right, and you don't have a will, what would happen is that the estate is, when you pass away, the court opens up the estate, right? And now it would become part of your estate, right? So what would happen is, let's say for instance, you passed away, all your assets, the court, somebody went out, opened up an estate, distributed your assets, closed the estate, right? Now the estate is closed, your parents pass away, right? And in their will, they said you get all the money. Now somebody will have to reopen the estate, right? And then the assets would be distributed. Now it could be distributed one of two ways. If you left a will, it would be distributed based upon what your will says. If you didn't have a will, there's the intestacy scheme the state has, which tells you where the money would go. So you would have to reopen the estate, the money will pour into that estate and then be distributed based upon either the will or the state system, right? And I'll take a question here. Yes, go ahead.
Can you clarify what the state means and how it links to will or trust? Is it an umbrella category?
Yeah, so an estate, right, an ESTAT, an estate is, it's something that's opened up when somebody passes away when you go to the court, right? So if you pass away, one of your family members would have to go to the court, open up an estate for you, and then once the estate is open, then the court would distribute your assets based upon one of two ways. One is if you have a will, then they will distribute the assets based upon the guidance in your will, or they will have to use the state law on how to do it. A trust is the only way to avoid the court system. It's a single only way, solitary way to avoid the court system is a trust. Okay. One question I want to answer, and I want to also answer your question here in a second. I had originally had a question about Sharia law, right, and about Islamic wills. Here's my personal take on this, okay? This has not been tested by the courts, but here's what I feel confident about. If you have a Sharia, if you have Islamic will that says, I want my assets to be distributed according to Sharia, and that's what it says, right? Or it's attaches a schedule of Marawat with it and says, distribute assets based on this schedule. It is not enforceable under Indiana law or the law of any other state that I know. Because here's what you're asking to do, okay? You're asking the judge to interpret Sharia law, right? Imagine that. Think about the connotation of that, right? You're asking the judge to sit there, open up the schedule of Marawat, and any ambiguity in that needs to be interpreted and resolved based upon Sharia and fiqh. And there's no judge in this country that will do that. So the only way for you to ever have a Sharia compliant, well, I've seen people do something along the lines of, instead of saying distribute assets based upon Sharia, they would just say, it goes to this person, it goes to this person, and that is based on. But the problem is you cannot take care of all the contingencies in your will if you do that. You will be writing all day, every day, and you will have to put in everything, right? And because you can never reference that schedule, you have to put it in the will. So that's the only way to do it if you're doing Islamic will. Now, the best way, I think the most feasible way to do that is through a trust. Because when I have set up Islamic Sharia compliant trust, what I've done is I've said, when all my assets must be distributed based upon Sharia law as interpreted by such and such resident scholar of this mosque. Right? And so I couldn't do that in a will, because what am I gonna do? Tell the judge we're gonna go to Sheikh, Imam this at Al-Huda. So, but I can't do that as a trust because my attorney is doing it as opposed to the judge who can do that. So then what you do is you go to that scholar, and that scholar then tells you how you should do it. And you can have contingent scholars after that in there. So I think that's the only feasible way to do Sharia compliance statement.
I just had a quick question about, what's your guidance for like young couples like us?
Yeah.
With trust and will and estate planning.
So I would say, obviously, you guys, as a young couple, you want to have a will, right? You want to have or you want to have a trust depending on whether you want to avoid divorce. If you are expecting, children in the future, you want to set it up so that it's not, the question that I'm guessing might be in the back of your mind as well, do we address the children issue now, or do we wait to set it up after we have children or things like that, right? Most of these trusts are set up in a way where the language is fairly generic, whether you have children now or not, you can always set it up, and it would just say, future born children will get this much money, right? Or like all the money will go to them, because most people, what they do is, after the husband, they leave everything to the wife, after the wife, they leave everything to the husband. When the second death happens, when the husband passes away, everything is distributed, or the wife passes away, everything is distributed equally to the children, right? That type of generic language is there anyways. It doesn't have to be that the kids are there for that purpose. Of course, the reality is most people become serious about estate planning once they have kids. But of course, it's, I have tons of young couples that are concerned. And then the other concerns that you have are this, right? There are, for young couples, and this is true whether you have kids or not. This was a conversation I had with my wife, an awkward conversation, but I had it with her, right? And that was, if you're a young couple, it is more likely than not that if one of the spouses passes away, the other one gets married, right? So let's play this out, right? Husband always dies first in my example. If you pass away, it goes to her, right? All your money goes to her. Now, if she was to get remarried and get divorced, half of your money goes to this guy, right? Or if you have kids in that scenario, half of the money you originally wanted your kids to have is ending up with this unrelated spouse. And that's a concern a lot of young families have to grapple with, like because you're young, so much could go wrong. And so what do you do to address that? And there are ways to address that issue, but that is something that I've heard young couples talk about.
And all of this is only true if you're dying, not in a divorce. That's different.
Well, if you divorce, right, you're gonna redo your plan, right? Because you still don't want your spouse to have all the money. So if you are divorcing, you more than likely 90% of the times you're redoing your plan. And when you redo your plan, that's taken care of. But the problem is if you die, now you can't redo your plan, you're kind of stuck with it. So you have to kind of account for all of these possibilities you don't want to think about, right? I had a friend who just randomly called me, and I went down this path of talking to him about what happens if his wife remarries some other guy. And he was like, man, like, I don't want to talk about this on a Friday evening. Let's talk later. So I mean, these are not comfortable topics to talk about, but you have to address them because anything can happen. So